question. Each H-1B company, H-1B dependent company, or companies which are using H-1B visa workers, must have a plan of action. Plan of action is you must have your HR folks ready to deal with this issue. When there is a knock on the door, as I told you before, you must have public access file in one filing cabinet, immigration file in another filing cabinet. And then you're going to hold these documents. You have complied with the LCA posting requirement at the end client. You're going to get that confirmation and put it in the public access file. So all of this documentation, you need to put it into the right perspective, right? And you're going to train your employees. When the officers come in, you're going to show them, sir, we comply with the law. Here is our public access file. If you want to see I-129 related documentation, you have I-129. You have a LCA, certified LCA. You have a petition letter. You have a degree diploma transcript. You have a passport visa I-94. You have a payroll records. Maybe W-2s, maybe recent pay stub, maybe if it's placed in end client, maybe the end client letter, contract PO. All of this documentation, you're going to have it. Now, your employees have to be able to communicate with the FDNS officers. So you're going to have to train them. Now, not only them, because the employee also needs to be trained how to deal with the FDNS officer. Maybe he's not going to come to the H-1B employer company. FDNS officer goes directly to the end client side. Now, end client has to be trained also. So you need to tell the end client, look, you might be receiving FDNS officer. FDNS officer might come to visit your company because Venkat Rao is working there or John Smith is working there. So if he is working there, then you want to tell them, okay? You want to tell the end client manager, if the officer comes to the reception area, if the FDNS guy comes in looking for Venkat Rao or John Smith, so-and-so manager must be notified. Have some internal protocol, internal channel of communication so the officer is not returned back. If they return back, they could deny the H-1 because they go to the H-1B company, nobody is there. They go to the end client side, they say, this is confidential, we cannot let you see. Or it's a chess bank, we cannot let you go up. There is too much money. So all this kind of nuisance answers is not going to satisfy, or their job is not going to be fulfilled. They cannot execute their task, finding out the bona fideness of the I-129 petition. So every party got to help the FDNS officer to find the truth so he can prepare a report, send it to the DC office as well as the service center which requested this FDNS site visit. So they have their own obligation to meet. So if you comply with these protocols and you have an end client manager is aware, then everybody can be on the same page. The truth will come out and the truth will set you free.